morning, friends, and sorry for the delay on our part because there was some technical glitch. And today, amongst us, we have Mr. Suryanarayan Rao, who is an epitome of knowledge, and he has always been sharing his knowledge on different issues and different perspectives. We thought, why not understand the rights in a coparcenary property as to how the law has evolved. And as we all know that Mr. Rao has always been kind enough to come and share the knowledge on the channel of Beyond Law CLC. Those who have missed the previous webinars, they can always check it out on our YouTube channel. And they can also like, subscribe, and share the link of the channel so that they can come to know as to what type of efforts is being put across. And sharing your comments on the YouTube channel would also tell us that what type of topics you want or what was your response to that particular topic. That will always encourage the resource person to take things forward in the right way. Since it's a weekend, we will request Mr. Rao to share his insights. Over to you, sir, and thank you for always agreeing upon to take different issues of law. Over to you.
Good evening, everybody. The subject of today's talk is rights in coparcenary property and how those rights have evolved from a long time. In order to understand this evolution of law, we have got to first understand a few concepts. First is, what is a coparcenary? What is a joint family? What is coparcenary property? These three things will have to be correctly in mind. The first and the most important thing is coparcenary. Coparcenary consists of father, son, grandson, and great-grandsons. So therefore, it is a male lineage only. And all these persons put together would constitute a coparcenary. Only males are members of this coparcenary, and females are not members of this coparcenary. Number two, in respect of all these males, their wives and their daughters also, daughters and daughter-in-laws put together, they would constitute a joint family. Whereas the male lineal descendants would become coparceners by birth, and they cease to be coparceners unless there is a partition only by their death. As far as females are concerned, they become members of a joint family when the daughters marry and go out. They cease to be members of the joint family, and when daughter-in-laws walk in, they become members of the joint family. So therefore, this is the distinction between a coparcenary and a joint family. Then coparcenary property is what a male acquires on succession from his father, grandfather, or great-grandfather. So if property is acquired from this particular source, from either the father, grandfather, or great-grandfather, it becomes coparcenary property. The son, grandson, and great-grandson, they become members of the coparcenary. They also acquire a right by birth in coparcenary property. So therefore, this is what is called as unobstructed heritage. The right that a coparcener acquires in coparcenary property is not dependent upon the death of the father, grandfather, or the great-grandfather. As soon as he is born, he becomes a member of the coparcenary, and he gets a right by birth in this coparcenary property. prior to 1933, the law was that women had no right in coparcenary property. Women, ladies, would not acquire any property even on succession to a male. It was only the males who were entitled to succeed to the assets of their father, and the females would not get any right at all. That was the law prior to 1933. And so for the first time, the two statutory enactments came into force. The first statutory enactment was the Mysore Hindu Law Women's Rights Act 1933, and this came into force on 29/6/1933. And the second enactment was the Hindu Women's Right to Property Act 1937, and it came into force on 14/4/1937. So by these two, in fact, the Mysore enactment was applicable to the state of Mysore that existed prior to the formation of the Union of India, and the provisions of that enactment are of great significance because this enactment in particular gave rights to daughters and widows in certain situations. If Section 4 of the Mysore Act is looked into, what Section 4 says is primarily the property of a male would first go to the son, grandson, or great-grandson. If all these three persons are alive, the daughters are totally excluded from succession. In the absence of these three people, the property would go to the widow. Only in the absence of the widow, the property would go to the daughter. So therefore, there was some room for the widow or the daughter to acquire rights in family properties under this particular enactment. Then two other concepts were also developed in this enactment. That is under Section 8, widows, unmarried daughters, and a few other females were entitled to a share at a partition in the joint family of joint family properties. Their right was confined only to a share when a partition of the joint family takes place. They had no right to sue for partition and claim a partition of share in these joint family properties. Their rights were confined only at a partition, and if there was no partition in the family, they would not get any right in the joint family properties. Then there was one other concept that was introduced. As far as Stridhana properties are concerned, that is self-acquired properties of a female are concerned, the law was that both sons and daughters, they would inherit the property in equal shares, only in respect of Stridhana properties. Then we may go to the Hindu, the other enactment which I made a reference, that is the Hindu Women's Rights to Property Act. This applied to other states other than the state of Mysore, which existed prior to the Indian Constitution. Now, this consists of practically 2 sections only. And the section 3 says, when a Hindu governed by Dayabaga school of Hindu law, dies intestate living property, and when a Hindu governed by any other school of Hindu law or by customary law dies intestate, leaving separate property. This is what is important. If a man owned self-acquired properties, his widow, or if there are more than one widow, all his widows together shall, subject to the provisions of section 3, be entitled in respect of the property in respect of which he dies intestate to the same share as a son. So therefore, they would get, the widow would get the same share as a son. That is with respect to the separate property. Then this subsection 2 says, when a Hindu governed by any school of Hindu law other than Dayabaga school or customary law dies having at the time of his death any interest in a Hindu joint family property. This is with respect to joint family property. His widow shall, subject to the provisions of subsection 3, have in the property the same interest as he himself had. So therefore, whatever share the husband had, it would go to the widow. And both under the Mysore Act and also the other act, whatever property was got by a Hindu female, she would only take a limited estate. She had only a right to enjoy this property during her lifetime. She could, even if she should make an alienation of the property, that would survive only as long as she was alive. After her death, the property would revert to the heirs of the husband. And all of us are aware that by virtue of section 14 of the Hindu Succession Act, whatever rights the female had, it would enlarge into a full estate if she was possessed of that estate on the date when the Hindu Succession Act came into force in 1956. Then for the first time, the Hindu law of succession was codified in the year 1956. Hindu Succession Act was brought into force. As far as section 6 is concerned, the law said that if a male Hindu died having an interest in coparcenary property, in such an event, a notional partition was assumed just before his death, and whatever property, whatever share that he would get at this notional partition, that share would go by succession to all his heirs. And under section 30, if a coparcener should make a will in respect of his property, he could even deprive of his heirs of class 1 of a share in these properties. So therefore, the rule of survivorship was stated in literal terms. A proviso was introduced to this rule of survivorship. The proviso was where a male Hindu died, leaving behind him a female heir mentioned in clause 1, or a male relative claiming through such female relative, then the property of the male Hindu dying would not go by survivorship. It would go either by succession intestate, or or if he has executed a will, whatever provisions are made under the will. To give a simple illustration, let us assume that the father had two sons and a daughter, and he had his wife also. In such a situation, if the father and the two sons constituted a coparcenary, immediately after the death of the father, a deemed partition by fiction was assumed, and at this deemed partition, the father got a 1/3 share, the two sons each, they got a 1/3 share each. So therefore, whatever share, this 1/3 share the father had, that would go by succession to his wife, to his daughter, and the two sons. So therefore, the sharers are 4 in number, 2 daughters, a son, and a widow. So therefore, this 1/3 share of the father is again shared by these two people, each one getting a 1/12 share. Thereby, the son would get a 1/3 share as a copartner, right by birth, 1/12 share on succession to his father. Therefore, the share of a son would be 1/3 plus 1/12, whereas the share of a daughter would be 1/12, and the wife would also get a 1/12 share. This is what would happen if the father did not leave a will. Suppose the father wanted to give this 1/3 share to his sons only, to his wife only, or to a person who is a total stranger in the family, and if he should execute a will, then the heirs of the father would not get this property, and the property would go according to what was willed by him, and therefore the father had every right to deprive his wife and daughter of any share in coparcenary property. This was the law in force when in the year 1956. Then after 1956, what happened was the Karnataka government amended Section 6 of the Hindu Succession Act, and they brought by including Section 6A and Section 6C, B, C, and D by substituting the original Section 6. So under Section 6A, what the statute said was, in a joint family governed by Mitakshara law, the daughter of a copartner shall by birth become a copartner in her own right in the same manner as a son, and have the same rights in the coparcenary property as she would have had if she had a son, inclusive of the right to claim survivorship, shall be subject to the same liabilities and disabilities in respect thereof as that of a son. So therefore, by this enactment, the Karnataka government said that a daughter also would become a copartner by birth. So therefore, the daughter also would become a copartner by birth from 30/7/1994. That was the date on which the Karnataka amendment was brought into force. And it also said the circumstances under which a daughter could claim a share in coparcenary property, because she became a copartner by birth from that date, and therefore under Section 6AB, this is what the enactment said. At a partition in such a joint family, the coparcenary property shall be so divided so as to allot to a daughter the same share as is allotted to a son. So therefore, what is important is at a partition is what is used in this particular section. So therefore, in my view, if when the Karnataka amendment was in force, if there is no partition at all in the coparcenary, even in such a situation, though a daughter was a copartner, she could not file a suit and ask for separation of her share. Only in cases where a partition takes place in the family, she would be entitled to a share and not otherwise. And there was also one other proviso introduced which said that a daughter who claims a share as copartner should remain unmarried as on the date of the amending act, that is 30/7/1994. So therefore, this right as a copartner given to a daughter was subject to another limitation, that is, she should be unmarried on the date of commencement on 30/7/1994. So therefore, this Karnataka amendment would be of no help to females who were married prior to 30/7/1994. And it would also apply to daughters who were born after 30/7/1994, because they would remain unmarried after 30/7/1994. So therefore, this the Karnataka amendment would apply to the entire state of Karnataka. So therefore, this law will have got to be kept in mind while appreciating the amendment to Section 6 by its substitution by Act 39/2005. That is, the central government brought into force a new concept by introducing a substituted Section 6. And this has created a lot of confusion in interpretation of this new provision of Section 6. In fact, under the Section 6, what they said was the law of survivorship was completely abandoned. And it said that a daughter would become a copartner by birth, number one. Number two, and she would be entitled to the same share as a son, and she would also be liable to the same disabilities as a son would suffer by being a copartner. This, in effect, is substituted Section 6 of the Hindu Succession Act. Now, there are one or two more things that have to be kept in mind in looking into this substituted Section 6 of the Hindu Succession Act. It also said that where the property was already divided by on a particular date, or where the property was given away by a will and the will had taken effect before a particular date, all those transactions would be saved. And in respect of those properties, the daughter could not claim any share in these properties. The effective date for this purpose is 20th December 2004. So therefore, whatever transactions had taken place before 20th December 2004 in respect of coparcenary properties, either by an alienation or by virtue of a will made by the coparcener, all those transactions were saved. Well, therefore, the provisions of this new section, which was brought into force on 9/9/2005, would only be available only in cases where transactions like this had not taken place before 20th December 2004. So these things will have got to be clearly kept in mind. Then there is one very important aspect about which there are a number of decisions which have created some confusion in this regard. Earlier, the Supreme Court had said in Prakash versus Pulavati that if a daughter or a father is not alive on 9 Hello. Hello. Hello.
So you can start.
Hello.
So you can start off.
Right. I was saying that in Vinita Sharma's case, the court primarily said that if a daughter is alive on the date when the act came into force, the provisions of the act, amending act, would apply to such a daughter and she would acquire the status of a co-partner. A reference may be made to some of the paragraphs in the judgment of the Honorable Supreme Court, which would be relevant, and we should correctly keep in mind these two principles laid down by the Supreme Court. A reference may be made to para 75 of the judgment in Vinita Sharma's case. This is what the Supreme Court has said. Survivorship is the mode of succession, not that of formation of a coparcenary. Hence, we respectfully find ourselves unable to agree with the concept of living copartner as laid down in Prakash versus Pulavati. So therefore, in our opinion, the daughter should be living on 9/9/2005. So therefore, the Supreme Court has said in unequivocal terms, for the amended provision of Section 6 to apply, the daughter should be living on 9/9/2005. Then a reference also can be made to paragraph 105, where their lordships have said, hence, we have no hesitation to reject the effect of statutory fiction of proviso to Section 6 as discussed in Prakash versus Pulavati Supra and Danamma Supra. If a daughter is alive, this is what is important. If a daughter is alive on the date of enforcement of the amending act, she becomes a copartner with effect from the date of the amending act, irrespective of the date of birth earlier in point of time. So therefore, their lordships have said, irrespective of the date of birth of the female, if the female is alive on 9/9/2005, she would be entitled to the benefit of the amended provision and she would become a co-partner from 9/9/2005. The Supreme Court has very clearly said that the amending act is not retrospective. It is only retroactive. It gives a right to the female as a co-partner from 9/9/2005, taking into consideration the anterior fact of the female having born earlier. So therefore, the concept of a living father was given a go by. The concept of the female should be living on 9/9/2005 was upheld by the Supreme Court in Vinita Sharma's case. However, there are two decisions of the Karnataka High Court which have taken a different view in this regard. That is, it is not a reported decision. It's a decision in RSA 1171/2015. The judgment is delivered on 21/22 in Ranga Shamaya versus Ranga Hanumaya. In this case, the court has said, even if the daughter is not alive on 9/9/2005, whatever may be his date of birth, the heirs of the daughter could claim the rights of their mother as a co-partner by filing a suit after 9/9/2005, though the mother was not alive on 9/9/2005. This is what the High Court has said. in paragraphs 19 and 20 of the judgment, which are relevant for the consideration. Once the daughter is conferred the status of a co-partner and acquires a right by birth, this acquisition of right by birth cannot be deprived by her death, whether it is before or prior to the amendment. So this is what they said. Even if she died earlier, she would become a co-partner, right as a co-partner. Then the creation of a coparcenary right is by birth and creates a right in the female by virtue of her birth in the family. Her death in the family, either before or after the amendment, will have no effect on her status as a copartner. Once she is born in a family, she becomes a copartner by operation of law, and this status is definite and perennial. The death of a daughter, whether it occurs before the amendment of the Act or after the amendment of the Act, would make absolutely no difference to her status as a co-partner. So therefore, this, in my view, this decision of the Karnataka High Court is not in consonance with what is laid down in Vinita Sharma's case. In Vinita Sharma's case, in paragraph 75 of the judgment, the court has unequivocally said, in our opinion, the daughters should be living on 9/9/2005. Then again in paragraph 105, it is stated, if a daughter is alive on the date of enforcement of the amending act, she becomes a co-partner with effect from the date of the amending act, irrespective of the date of birth earlier in point of time. Therefore, my submission is these two relevant observations of the Supreme Court have not been taken note of by the Karnataka High Court while rendering this decision. Then there is one other decision of the Karnataka High Court which has also held a similar view, and I would make a reference to the decision. That's also an unreported decision in RSA 2893/2006. It is disposed of on 5/10/2021. This is what the learned judges observed at para 35 of the judgment. Learned counsel for appellant defendant number 1, V. Ramaya, in RSA 2629/2005 submitted that as per the principles laid down in Vinita Sharma's case, the children of deceased daughter are not entitled for the share equivalent to that of a deceased daughter if the said daughter died earlier to the Amendment Act 2005. In this connection, the contextual reading of the judgment guides that the daughter is treated equivalent to that of a son and has all the rights of a co-partner. Her rights are enforceable by their children. There is not much of a discussion made in this second decision. They have also come this in the second decision also. Their lordships have come to the conclusion that even if the daughter is not alive on 9/9/2005, and they would be in the heirs of such a daughter could claim that their mother had become a co-partner, and they would also be entitled to that share in the joint family properties. Therefore, these two decisions of the Karnataka High Court, which are not reported, according to me, with great respect to the honorable judges, is per incurium, and therefore these two decisions are required to be reviewed. So this is one aspect of the matter. Then in Vinita Sharma, you see, then the concept of a notional partition under Section 6 of the Hindu Succession Act was explained in great detail by Justice Y.V. Chandrachud in a decision reported in AIR 1978 Supreme Court 1239, Gurupad Kandappa Magadam versus Hirabai Kandappa Magadam. The Supreme Court in this case has stated the law like this. The explanation 1 to section 6 of the Hindu Succession Act resorts to the simple, expedient, undoubtedly fictional, that the interest of a Hindu Mitakshara co-partner shall be deemed to be the share in the property that would have been allotted to him if a partition of the property had taken place before the death. What is therefore required to be assumed is that a partition, this is what is important, that a partition had in fact taken place between the deceased and his co-partners immediately before this death. The assumption once made is irrevocable. In other words, the assumption having been made once for the purpose of ascertaining the share of the deceased in the coparcenary property, one cannot go back on the assumption and ascertain the share of the heirs without reference to it. The assumption which the statute permeates, the assumption which the statute requires to be made that a partition had in fact taken place must permeate the entire process of ascertainment of the ultimate share of the heirs through all its stages. So therefore, the court said that a partition is assumed. It is as if a partition has in fact taken place, and the assumption once made is irrevocable. So therefore, the law was that as soon as one of the co-partners died, in view of this notional partition, the joint family status would come to an end. That was the law earlier, and it was also held that the shares of the other living co-partners also would get determined at this notional partition. Then, this concept of notional partition was again given a relook by Justice E.S. Venkatramaya in a decision reported in AIR 1985 Supreme Court 716. After referring to the earlier case of Justice Chandrachud, this is what Justice E.S. Venkatramaya has said at paragraph 9 of the judgment. We have carefully considered the above decision, that is Chandrachud decision, and we feel that this case has to be treated as an authority for the position that when a female member who inherits an interest in the joint family property under section 6 of the Act files a suit for partition, expressing her willingness to go out of the family, she would be entitled to get both the interest she inherited and the share which have been allotted, which have been notionally allotted to her, as stated in explanation 6, section 6 of the Act. But it cannot be an authority for the position that she ceases to be a member of the family. So therefore, the disruption of the joint family does not actually take place. But it cannot be an authority for the position that she ceases to be a member of the family on the death of the male member of the family whose interest in the family property devolves on her without her volition to separate herself from the family. A legal fiction should no doubt ordinarily be carried to its logical end to carry out the purpose for which it was enacted, but it cannot be carried beyond that. It is no doubt true that the right of a female heir to the interest inherited by her in the family property gets fixed. So therefore, her right gets determined, gets fixed on the date of the death of the male member under Section 6 of the Act. But she cannot be treated as having ceased to be a member of the family without her volition, as otherwise it would lead to strange results which could not have been in the contemplation of the Parliament when it enacted that provision, which might also not be in the interest of the female heirs. It should therefore be held, this is most important, it should therefore be held, notwithstanding the death of Shamarao, that is the father, the remaining members of the family continued to hold the family property together, though the individual interest of the female member thereof in the family property became fixed. So therefore, the share got fixed, but it was not divided by metes and bounds. The joint family still continues when she could file a suit for partition in respect of a share which was fixed on the date when her husband died. So this is the so therefore the notional partition is only for the purpose of determining the share of the heirs of the deceased co-partner, and it does not in fact bring about a disruption of the joint family. And that is what is stated in this particular judgment. Then this decision is also subsequently followed by the Supreme Court in AIR 1994 Supreme Court, page 182, Shama Devi versus Manju Shukla. So therefore, these two decisions completely interpret the effect of Section 6 prior to Vinita Sharma's case. Then in Vinita Sharma's case, what they said was that after the 2005 Act, even at this notional partition, there was no division of status also. This notional partition was primarily meant for defining the shares of the heirs of the co-partner who died. It does not fix the share of the other co-partners as on the date of the death of one of the co-partners. This is what the Supreme Court has said. In fact, a few paragraphs in the judgment in Vinita Sharma's case would be very relevant, because unless we read all these paragraphs carefully, we will not be able to understand how the concept of notional partition will have got to be applied while trying to find out the share of a daughter as a co-partner subsequent to 9/9/2005. Now, at the end of paragraph 96, the Supreme Court makes a reference to Chandrachud decision, and this is what the Supreme Court has said in Vinita Sharma's case. The only question involved in the aforesaid matter was, that is in the Chandrachud judgment, was with respect to explanation of Section 6 and the determination of the widow's share. In that case, the question was not of fluctuation in the coparcenary body by a legal provision or otherwise. Therefore, the application of Chandrachud's decision is now changed by virtue of the legal provision in Section 6, where the daughters are made co-partners. Therefore, everything remained static. No doubt about it. The share of the deceased has to be worked out as per the statutory fiction of partition created. However, in case of change of body of co-partners by a legal provision or otherwise, so that is by virtue of this amendment, unless and until the actual partition is finally worked out, rights have to be recognized as they exist at the time of the final decree. It is only the share of the deceased co-partner and his heirs are ascertained under the explanation to section 6 and not that of the other co-partners which keep on changing with with birth and death. Then again in paragraph 110, when the proviso to unamended section 6 of the Act 1956 came into operation and the shares of the deceased co-partner was required to be ascertained, a deemed partition was assumed in the life of the deceased immediately before the check. Such a concept of notional partition was employed so as to give effect to the explanation to section 6. The fiction of notional partition was meant for an aforesaid specific purpose. It was not to bring about a real partition. This is important. Neither did it affect the severance of interest nor demarcated the interest of the surviving co-partners or the other family members. So therefore, it is only the share of the co-partner who died that was predicated and that was fixed. The shares of the other co-partners was not fixed at all. Therefore, see, I will give you a very simple illustration. A father and two sons and a daughter. The father died subsequent to 9/9/2005. Then what happens? The share of the father, the father died prior to 9/9/2005, not after 2005. Then what happens is the share of the father prior to 9/9/2005 would be 1/3 share, because father and two sons, they only constitute a coparcenary. So therefore, the share of the father would get determined, and this father's share would go by succession to his two sons, a daughter, and the mother, and they say the mother. So therefore, there are four people. So this 1/3 share would be divided between the two sons, the daughter, and the widow. All would get a 1/4 of 1/3, and it will be a 1/12 share. So therefore, what happens at this notional partition is this 1/3 share of the father gets excluded, and the father and his heirs would get 1/12 share each in the property because of the death of the father. And therefore, the remaining 2/3 share, it would continue as joint family property. And suppose after the act came into force, the daughter would be a co-partner. So therefore, the daughter and the son, those are the only two people in the coparcenary at that time, because the daughter also becomes a copartner from 9/9/2005. This 2/3 share would be joint family property, and this 2/3 share itself would be shared by the son and the daughter in equal share. So therefore, they would only, those two people would share this 2/3 share, and that will be joint family property in their hands. They will get half of this 2/3 share each in the joint family properties. And suppose with the aid of this 2/3 share, they acquire some more properties. Then what would happen? See, whatever properties are acquired with the aid of this 2/4 share, it would be coparcenary property between the surviving son and the daughter only. And the daughter, the son who died prior to 2005, they would not be entitled to any share in these properties. So therefore, the concept would create lot of confusion. So therefore, it revolves around a very careful application of the law depending upon the date of death of the co-partner. So and if he died prior to 9/9/2005, the share of the deceased co-partner, which is ascertained at a notional partition, would embrace only those properties which belong to the joint family on that date. If joint family properties are subsequently acquired with the aid of coparcenary properties, the heirs of the deceased co-partner would not be entitled to the benefit of the properties which are subsequently acquired with the aid of joint family properties. In fact, this is what is also made clear by the Supreme Court in at paragraph 104 of the judgment. This is what is stated in paragraph 104. In case the coparcenary is continued, so therefore the share of the deceased is taken away. And in the case the coparcenary is continued, and later on between the surviving coparceners partitions takes place, it would necessary to find out the extent of the share of the deceased coparcener. That has to be worked out with reference to the property which was available at the time of the death of the deceased coparcener, whose share devolved as per proviso of explanation 1 to section 6, and in case of intestate succession. So therefore, the law, according to me, is so confusing, and we have got to bestow our attention to each one of these decisions in Vinita Sharma's case to understand the law correctly. Then in fact, the earlier law was, suppose a daughter filed a suit for partition, a co-partner filed a suit for partition, or a notice was issued by one of the co-partners seeking a partition. In all such, or a death takes place and a notional partition is made as required under explanation to section 6. In all these situations, the law prior to 1956 was that the co-partner, that the joint family status would come to an end. There would be a severance of status in the joint family. And once there is a severance of status, the shares of each one of the co-partners would get predicated. And if the shares of each one of the co-partners get predicated, then it would not be subject to a fluctuation at a later point of time. But the Supreme Court has said, filing of a suit, issue of a notice for partition, or the death of a co-partner, none of these things would bring about a change in the status of the co-partner so as to deprive a daughter of a share in the as a co-partner in the joint family properties. So therefore, the law appears to have undergone a change after 2005. Now, if that is so, if a suit is, what happens? If a suit is filed prior to 2005. So according to me, if a suit is filed prior to 2005, or if a notice for partition is given prior to 2005, there is a division of status. The shares of each one of the co-partners get predicated. On 9/9/2005, the joint family is not in existence. If that is so, the daughter would not get a right as a co-partner because there is a division of status prior to 9/9/2005. because the Supreme Court has said because of the amendment, we have got to interpret and say that none of these things would affect the rights of a daughter as a co-partner. Therefore, if after 9/9/2005, giving of a notice, filing of a suit, or the death of a co-partner, it does not bring about division of joint family status. Whereas, prior to the amendment, all these situations would bring about a division in the status of the coparcenary, and the shares of all the members of the family would get predicated. And there is one other factor also, which has not been discussed by the Supreme Court in Vinita Sharma's case. The wordings used in explanation to Section 6 of the Unamended Act is that a deemed partition has taken place immediately prior to his death. Partition means partition amongst all the members of the coparcenary. If it was intended that the share of only the coparcener who died had to be fixed, and the rights of the other sharers would not get fixed, the Supreme Court would have said, if he had released himself from the family, let a notional release was what would have been intended under explanation to Section 1. In a notional release, only one person goes out. In a partition, there is a division of status of the entire family. So therefore, the wordings used in Section 6 is not a notional release of one of the members of the coparcenary to find out his share, and what is contemplated under explanation is a partition. Therefore, the word partition has a specific meaning, and therefore we have got to interpret this particular explanation as saying that by the death of one of the copartners, the deemed partition would not only fix the share of the deceased at the time of his death, but also the share of other copartners in the joint family. This is my opinion in regard to the interpretation of the word partition in amended Section 6 of the Hindu Succession Act. Now, we see the most important thing is for application of Section 6, there must be coparcenary property. If coparcenary property is not there, the question of right by birth does not arise at all. So therefore, Section 19 of the Hindu Succession Act and Section 8 of the Hindu Succession Act, if they are carefully read, most of the property which is acquired subsequent to 1956 would all be self-acquired properties of the members of the joint family. They would not partake the character of joint family properties at all. Suppose if the grandfather acquired a property after the Hindu Succession Act 1956, that is subsequent to 1956, then it is self-acquired property in his hands. If the grandfather dies, the property in the hands of his son would not be joint family property, though the property is acquired from the father, because the Supreme Court has said in a number of decisions, because the property is acquired by the father on succession to the grandfather under Section 8, the property would be self-acquired property in his hands. And therefore, the grandson would have no right in these properties. In fact, for this proposition, there are a number of authorities in this regard. That is, I would make a reference to only few of them. the leading authority in this, the first and the most important authority is one, year 1986 Supreme Court, page 1753, Kapoor and others versus Chandrasen. This is what is popularly called as Chandrasen's case. In this case, the court said, as stated above, after coming into force of the Hindu Succession Act 1956, self-acquired or separate property of a male Hindu, that is, the grandfather acquiring the property after 1956, on his dying intestate, devolves on his heirs in their individual capacity. So therefore, it devolves upon the father in his individual capacity and not as coparcenary property. In such a case, their children, that is the grandchildren, will not acquire any right by birth in such property. This was what was laid down, and this principle was followed in 1987 Supreme Court, page 558, Yudhishthir versus Ashok Kumar. And this is what the court has said. The court observed that this position, that is the property have acquired, that the father acquiring property from the grandfather would become his would become ancestral in his hands. That was the earlier law. This court observed that this position has been affected by Section 8 of the Hindu Succession Act 1956, and therefore, after the act, that is 1956, when a son inherited the property in a situation contemplated by Section 8, he does not take it as karta of his own undivided family, but takes it in his individual capacity. And they also said, yeah, if that be the position, when the property which devolved upon the father of the respondent in the instant case on the demise of his grandfather would not be said to be HUF property. So therefore, there are a number of decisions in that regard. Again, another decision in year 2008 Supreme Court, page 1490, and the latest decision is 2019 SAR Civil 809 Ashrur Singh versus Harpal Kaur. They say in paragraph 816, at page 816, paragraph 7.5, this is what is stated. After the Hindu Succession Act 1956 came into force, this position has undergone a change. Post 1956, if a person inherits a self-acquired property from his paternal ancestor, the said property becomes his self-acquired property and does not remain coparcenary property. So this law is also followed in a number of decisions by the Karnataka High Court, and I do not would not like to burden further with a large number of authorities on the same proposition. Therefore, what I would like to emphasize is, if property is acquired by either the father or the grandfather or the great-grandfather after 1956. So now we are in 22, 44. 44 plus 22, 66 years. In the last 66 years, if any one of these people, father, grandfather, or great-grandfather, has acquired this property after 1956, so therefore the property acquired by the great-grandfather would be self-acquired property in the hands of the grandfather. That property again would be self-acquired property in the hands of the father. Again, that property would be self-acquired property in the hands of the son. As long as they are alive, their sons or grandsons cannot claim any share in these properties. Therefore, if all these properties acquired after in the last 66 years by the family would not partake the character of joint family properties at all. And all these properties become self-acquired properties in the hands of whoever upon whom it has devolved in these last 66 years. Therefore, probably a large chunk of property which would have been otherwise the coparcenary property are taken out, and therefore section 6 does not apply to any of these properties. So this is one aspect of the matter. Then the second aspect of the matter is, suppose there are coparcenary properties. There is a division of these properties. When once a division takes place, then the property that are taken by the individual coparceners at a division, they would become self-acquired property in their hands by virtue of section 19 of the Hindu Succession Act. I will give you a simple illustration. There is a father. The father has 2 sons and 2 daughters, let us suppose. The father dies. The 2 sons and the 2 daughters, let us say they are all coparceners. They get a 1/4 share in these properties. And all of them divide this 1/4 share. After 1956, what happens is, this 1/4 share in the hands of the father, though these properties are acquired or coparcenary properties earlier, they become self-acquired properties after a partition takes place between these 4 persons. Therefore, only those persons who are alive on the date when this partition takes place, they would be entitled to a share. Suppose a son is born subsequent to this partition, he would not get a right by birth. I'll give you a simple illustration. In fact, that's also what the Supreme Court has said in one of those cases. The grandfather is alive. He has got 2 sons and a daughter. So the grandfather dies. The 2 sons and the daughter, they form a coparcenary. The 2 sons and the father, the 2 sons and the daughter, they divide the property 1/3 each and they take their shares. Suppose after this partition, one of these sons gets another child. The child born after the partition or after the death of the grandfather, because the grandfather's property gets shared after the death of the grandfather, he would not be entitled to any share in these properties. And in fact, this principle was first laid down by the Supreme Court in a decision reported in AIR 2008 to Supreme Court 2489. This is Haridev Rai versus Shakuntala Devi. In fact, is one concept which has got to be very clearly kept in mind. Once the share of a coparcener is determined, it ceases to be coparcenary property. The parties in such an event does not possess the property as joint tenants, but as tenants in common. The decision of this court in SBI, therefore, is not applicable to the present case, where this is what is important, where a coparcener takes definite share in the property. He is the owner of that share, and as such, he can alienate the same by sale or mortgage in the same manner as he can dispose of his separate property. So when once he gets a share at a partition after 1956, it becomes his individual property, and his sons born subsequent to the partition cannot claim any share. In fact, we have got to read section 19 very carefully. If section 19 of the Hindu Succession Act is closely read, we will just read section 19 of the Hindu Succession Act. This is what section 19 reads. In fact, this provision is lost sight of in many cases. If 2 or more heirs succeed to the property of an intestate, they shall take the property, save as otherwise expressly provided in this act, per capita and not per strips. So they take it as per capita and not per strips. And as tenants in common and not as joint tenants. So therefore, they unless they take it as if they take it as joint tenants, it will be joint family property. If they take it as tenancy in common, it would be their individual property and not joint family property. So therefore, per capita would mean that whoever is alive on the date when the succession opens, they would only be entitled to a share. And those persons who are born subsequent to this succession, they would not be entitled to a share in this property. So if section 19 of the Hindu Succession Act is closely read, the wordings in that section indicate that the same would be applicable to cases where there is a succession of property after the Hindu Succession Act came into force. The word used in this section is succession and not inheritance. For this reason, this section applies both in case of acquisition of joint family property at a partition or by inheritance. For this reason, where a partition takes place subsequent to 1956, even of ancestral property, the parties to the partition acquire the property in their individual capacity, and their children who were neither born nor alive on the date of the partition would not get any share in the properties which are the subject matter of the partition. This is the principle affirmed by the Supreme Court in the decisions which I have already referred to. So in this, in fact, this decision of the Supreme Court is further affirmed in a recent decision of the Supreme Court in 2020, SAR Civil 127. That is Radhabai versus. So in this case, the principle laid down in Hardio Roy's case was affirmed, and the facts of that case make the law further clear. In the case before the Supreme Court, the grandfather was one Jagannath Singh. He died in 1973. He owned Coparcenary properties. The joint family consisted of the father and the sons. The grandson, who was born in the year 1977, after the death of the grandfather died in 1973. There was a notional partition, that is, there was succession to the properties. The properties vested in his sons. So the grandson filed a suit for partition, claiming a 1/4 share in the joint family properties. The Supreme Court held that as on the date of the death of the grandfather, the plaintiff grandson was not alive. At a notional partition, the plaintiff would not get any share. Further, as the property which had already vested in the father in the year 1973 and acquired the character of self-acquired property in view of section 19 of the Hindu Succession Act, the grandson had no right in these properties. A close reading of this section, that is section 19, would indicate that the property was held to be ancestral property in the hands of Jagannath Singh, and this property loses the character of joint family property on the death of Jagannath Singh, and therefore it was held that the grandson who was not born on the date of death of the grandfather would not be entitled to a share in the joint family properties. In fact, a similar question also arose in another decision of the Supreme Court in AR 2016, Supreme Court, page 1169. In fact, in this Uttam's case, the law prior to 2005 has been nicely stated by the Supreme Court in 6 principles. And what is relevant for us is principle number 6, which reads as follows. On a conjoint reading of section 4, 8, and 19 of the Act, after joint family property has been distributed in accordance with section 8 on the principle of intestacy, the joint family ceases to be joint family property in the hands of various persons who have succeeded to it, and they hold the property as tenants in common and not as joint tenants. So therefore, this is what the court has held in all these decisions. Now, in view of what the Supreme Court has said in Vinita Sharma's case, we will have to find out whether a relook would be required in respect of this interpretation, because see, at a notional partition, the Supreme Court assumed that the shares of all the co-partners is determined. So then now the Supreme Court has said in Vinita Sharma's case, it is only the share of the co-partner who died that only gets predicated. The shares of the other co-partner does not get predicated after 9/9/2005 because of the amendment. Therefore, whether these decisions would apply or not, and whether the principle in Vinita Sharma's case has got to be applied along with the principles laid down in these 3 decisions, will have got to be carefully looked into and analyzed. That's also one gray area which requires little more light. So therefore, we will find that a large chunk of properties practically would partake the character of self-acquired properties, and when there is no coparcenary property at all, the discussion in regard to section 6 would only become academic. So therefore, all properties acquired by father, grandfather, great-grandfather after 1956, all those things become self-acquired properties. All properties which are partitioned after 1956, whoever gets a share, all of them would be self-acquired properties. What else is left to say that there is coparcenary property on which section 6 can act upon? So therefore, according to me, section 6 would operate only in a very limited field. I think it is only on a very minor section. So only on those properties. In fact, as stated by the Supreme Court in Ashur Singh's case, if the property is acquired by the grandfather prior to 1956 Act, and if the grandfather dies after 1956, such property alone will be joint family property. So therefore, those properties which are acquired by any one of the family as lineal ascendants prior to 1956, and that person should die prior to 1956, only in such situation it will be coparcenary property and not otherwise. So therefore, the discussion with regard to section 6, according to me, is more academic because it operates in a very limited field where the property is coparcenary property. So therefore, the primary attack for getting out of section 6 is always to find out whether we can say that the property is self-acquired property or coparcenary property. If we can bring it under section 19 or section 8, then section 6 would not apply, and therefore the section 6 will have no application in such cases. So therefore, these are very important questions that will have got to be kept in mind. There is one other area which we have got to bestow our attention, that is whether the Karnataka amendment would still apply or not, and what is the period during which this Karnataka Act applies. Then for that, there is a leading decision of the Karnataka High Court, a bench decision rendered by Justice B.V. Nagaratna and Justice and another, where that is a decision reported in ILR 2020 Karnataka, page 2697. In fact, this act came into force on 30/7/1994, and the amendment to the section 6 of the Hindu Succession Act came into force on 8/9/2005. So therefore, by virtue of the central enactment, the provisions of the Karnataka Act would get superseded, would get eclipsed, and therefore the Karnataka Amendment Act would not apply after 9/9/2005. So therefore, where the daughter, where there is an unmarried daughter after 30/7/1994, or where a daughter is born between 30/7/1994 and 9/9/2005, she would acquire a right as a copartner. And that right as a copartner could be exercised. And this is what the High Court has said in that bench decision. The central amendment would apply from 9/9/2005, the applicability being predicted on when succession opens and availability of the properties, that is, that they are neither partitioned or sold by way of a registered instrument. Therefore, this is what the court has said. After review of the earlier judgments, that the period prior to 9/9/2005, going back to 30/7/1994, would therefore be occupied by the Karnataka Amendment, the same not having been repealed by the Karnataka legislature, but having only been eclipsed by the central amendment of the Karnataka Amendment Act of the Hindu Succession Act, in terms of section 6A and 6C, would apply from 30/7/1994 to 8/9/2005 in view of the ratio laid down in Prakash versus Pulavati Supra. So therefore, when we can actually apply this Karnataka amendment. Suppose a daughter remained unmarried after 30/7/1994, and she died prior to 9/9/2005. For such daughters, we can apply the Karnataka amendment, and the heirs of such daughters could say that they are entitled to a share in the properties, as if her mother was a copartner when she died. So therefore, this aspect of the matter will have got to be kept in mind. So the date of death, the date when the coparcenary actually opened, succession actually opened, these things will have got to be clearly kept in mind. And I did not go into the other earlier aspects of saying that in the coparcenary, the shares are not predicated unless there is a partition in the family properties. There is always an increase in the share by the death of a copartner and decrease in the share by the birth of a copartner. And all those things, they are all settled principles. I just wanted to concentrate on the law that that is subsequently developed in view of Vinita Sharma's case, because that would be more relevant for the purpose of this discussion. And there is one other important conclusion which the court has arrived at in Vinita Sharma's case. In fact, that one sentence in Vinita Sharma's case, the application of which could be very important in this case. That is, I make a reference to paragraph 64 of the judgment in Vinita Sharma's case. This is what the judgment has said. The effect of the amendment is that a daughter is made a copartner with effect from the date of the amendment. She can claim partition also, which is a necessary concomitant of the coparcenary. Section 6(1) recognizes a joint Hindu family governed by Mitakshara law. The coparcenary, this is what is important. The coparcenary must exist on 9/9/2005 to enable the daughter of a copartner to enjoy rights conferred on her as the right by birth and not by dint of inheritance. It is relevant that a copartner whose daughter is conferred with the rights is alive or not. Conferral is not based on death of the father or other copartner. So therefore, the coparcenary must exist on 9/9/2005. So if emphasis is given to this particular section, what happens is, suppose a suit is filed prior to 9/9/2005, or a notice issued prior to 9/9/2005. There is a division of status. The coparcenary has come to an end. So even in such situations, the amended act would not apply. That is one other important aspect of the matter. And there is also one very important factor which has got to be kept in mind. Suppose prior to the amending act, the father dies. There is a notional partition in the family, and the shares of all the sharers get predicated, and all those shares, when the share of all those sharers become their self-acquired property. And with the aid of those properties which are self-acquired in the hands of the surviving copartners, they acquire other properties. Then what happens to this property? The property so acquired would not become joint family property. Those properties only become joint property in the hands of the acquirers, and therefore their sons would not get any right by birth in these properties. In fact, there is one decision of the Supreme Court in this regard where they make a distinction between joint family property and a joint property, and how this property will have got to be looked into. See, that was a case where the property belonged to the father. The father died subsequent to acquired the property subsequent to 1956, and he died after 1956. So therefore, all the four sons got their shares in this property by succession to the father, and therefore by application of section 8, these properties become self-acquired properties in the hands of the grandfather. So in the hands of the father. The grandson filed as, and with the help of these properties, which were self-acquired property in the hands of these four people, few other properties were also acquired. So therefore, a suit for partition was filed in respect of those properties which are jointly acquired by the father and his brothers jointly subsequently. This is what the Supreme Court has said. In fact, I would read only a few sentences from the decision of the Supreme Court in this case. In view of the interpretation of the full bench of the Madras High Court, that the sons in such a situation would get self-acquired property of their father by inheritance, having the status as tenants in common. They could thus treat such properties in their hands, even though joint in enjoyment, as Hindu family properties. Likewise, the income derived therefrom, if employed to purchase other property, would not cloak the new acquisition with the character of joint Hindu family property, but may otherwise be joint properties. So they would only be joint properties, they would not be joint family properties. Then again, if the parties herein were co-owners of that property, and the said property had been purchased from the income derived from joint property, then obviously the same has to be accounted for as joint property and not as joint family property. For what we have said above, it is plain that the property in possession of these two branches of the family sought to be partitioned was not joint Hindu family property, because these three sons obtained it by inheritance from their father. The last elder and their status was that of tenants in common. So therefore, if the property is in the hands of the sons, they were joint properties and not joint family properties. Therefore, the property acquired with the aid of these joint properties would also be joint property and not joint family property. So therefore, this concept is kept in mind. As I've already said, there is very little area where section 6 can operate, because there is very little area where we can say with certainty that the property is coparcenary property. Therefore, I think I have taken more time than what was allotted to me. And thank you very much for having given me a patient hearing. I thank Mr. Vikat Chatra for having given me an opportunity to be on this stage along with a large number of legal luminaries. Thank you. Thank you very much. Hello. Chatrat, you are muted. Unmute yourself. Hello. 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 No, tell me, sir. Tell me, sir. Ah, ah, ah. Anyway, there are any questions? No question. In fact, they wanted only one citation. Right. They wanted only one citation. Probably that I can give. No, right, sir. So in that case, I shall disconnect myself. Shall I disconnect myself in that case? Shall I disconnect myself now? Yeah, right. Thank you. Thank you all.